Free speech. We supported a case called Citizens United versus Federal Election Commission, better known as Hillary the movie. And the Federal Elections Commission ruled that the people at the production company Citizens United could not broadcast the movie. The Federal Elections Committee censored a movie about politics because it was happening too close to, it would happen too close to an election. We supported that case with an amicus, friend of the court, brief. And fortunately, the Supreme Court ruled in favor of free speech. And the core issue in that case was, if I have free speech rights to talk, shouldn't I also have free speech rights if the four of us form a corporation and say the same thing? Do somehow these rights disappear by moving from one form, the individual, to another form, the corporation? And so, even prior to this case, there were 25 states that allowed corporate speech, and I think the backlash to that case is unjustified. And so that's an example of our free speech work. School choice. In 1956, Governor Orville Freeman, a DFLer, gave a tax credit to parents who sent their children to private and parochial schools. He did that before Milton Friedman wrote his article about school vouchers. Minnesota was in the lead in terms of subsidizing the educational choices of parents who wanted to send their children to alternatives to the public schools. Rudy Perpich expanded it further. Arnie Carlson did it further, and we have defended, and we have charter schools. But the vouchers and the tax credits have always upset the teachers' unions and the ACLU. And inevitably what happens is that a state legislature, whether it's in Minnesota, in Arizona, in Ohio, will pass some legislation involving school choice. And on the Friday before Labor Day, the Friday before school is going to start on Tuesday or Wednesday, the ACLU and the teachers union march into court and ask for an injunction claiming that the voucher or tax credit is unconstitutional. Fortunately, the United States Supreme Court, in a case involving the Ohio voucher, Cleveland voucher program, said that school vouchers, when offered with a menu of choices, the Lutheran school, the Catholic school, the independent secular school, the Buddhist school, when parents receive the subsidy and they have a menu of choices, that is not the establishment of religion. That is the subsidies of parents who want to choose alternatives to the public school, and those laws are constitutional. So in that case, the Supreme Court got it right, and Cleveland's voucher program was upheld, and we assisted the Attorney General in Ohio defending. This is the one time where we stand shoulder to shoulder with the government, and we defended the school choice program, and we have done it for other states, including the Milwaukee voucher program and lots of tax credit programs in Cleveland, in Arizona. So that is, any questions about free speech or school choice?
What's the theory behind the continuing litigation if it was that clear? Like in Arizona, are they making state law claims? Or?
Yes.
Okay.
In Arizona, there are a couple of state constitutional provisions in many states, and they are known as Blaine Amendments.
Yeah.
Senator James G. Blaine of Maine was Speaker of the House in 1874, and he ran as a Republican for president. Didn't make it, but he wanted to address some of the pressures that existed at the time with the wave of Catholic immigrants who had come to the United States in the 1840s and the 1850s and after the Civil War, because public schools at the time were run by Protestants. The term common school does not refer to common as in universal or as in the common square. The term common school refers to the common tenets of the different Protestant denominations, what the Lutherans, the Baptists, the Anglicans, the Episcopalians all shared in common, and that was the religious foundation of common schools. That was the foundation of public schools when they were first introduced in Massachusetts in 1830. So when this wave of Catholic immigrants came forward, they wanted funding for Catholic schools. Well, Senator Blaine thought that was a bad idea. He attempted to amend the United States Constitution and failed, but he was successful in amending about 30 state constitutions, putting in words that exist today in the Minnesota Constitution, prohibiting aid to sectarian institutions in Article 13 of the Minnesota Constitution. So the ACLU and the Teachers Union, having lost all federal claims, now sue under state constitutions, and their batting average is less than 500. So we continue to fight them.
It's the same though in higher education though. I mean, not that they're private, but they're faith-based, a lot of them too, and couldn't they make the correlation in some type of
the GI Bill has been fantastic in terms of giving an example for higher education. In that, if you are a returning veteran, you can go to Gustavus Adolphus, you can go to St. Thomas, you can go to Yeshiva, you can go to Southern Methodist. There's lots of, and the federal program has been upheld. What the ACLU and others and the Teachers Union argue is that students are different than adults. Now, we don't think that difference matters because parents are making decisions, but one of their arguments is that children are different and are more influenced by religious teaching. How about that? God forbid.
Yeah.
So,